Good morning, I'm Mike Forsyth of MGF Attorneys from Hilton, KwaZulu-Natal, South Africa. Today I'd like to speak to you about using a special or general power of attorney. I'm often asked by family members to advise on the use of a special or general power of attorney where there is an elderly relative or spouse who has signed such a document and is now mentally incapacitated. The short answer is that our law of agency specifies that an agent cannot do that which his principal has no capacity to do himself. So once a person has lost their mental capacity, they are unable to process things on their own behalf, and the power of attorney then falls away and is of no further use and effect. I'm sometimes confronted with outrage when I deliver this news to the family. How can I possibly say this? They have been granted a power of attorney by their spouse or by their parents, and they wish to continue using this power of attorney. I'm afraid this is simply not possible. If the estate of the person is of considerable value, then you can make application to the High Court for the appointment of a curator ad litem. A curator ad litem is appointed to litigate on behalf of the person who is incapacitated, and who will then go out and interview the person who's incapacitated, and will also get reports from psychiatrists and general practitioners to enable the court to make a decision on whether the person is or is not able to manage their own affairs. If it is found that the person is incapable of managing their own affairs, the court appoints what is known as a curator bonus, who is then appointed to curate that person's affairs, to take charge of their bank accounts, share portfolios, properties, and to act on their behalf. The curator bonus has to provide regular reports to the Master of the High Court to show how they have been administering that person's estate. The difficulty is that many estates are simply not big enough to warrant the expense of applying to court. What to do in this circumstance? There really is not an easy answer. That power of attorney has fallen away and is revoked, and if you continue to use it, you run the risk of being sued by other family members or by a third party because you have not been administering that person's affairs correctly. Many people do continue to do this. My advice is be ultra careful should you decide to do this because of the risks involved. And as I say, once the person is mentally incapacitated, that power of attorney falls away. So your use of any power of attorney signed by that person after their mental incapacitation is of no further force and effect. There are many countries in the world which have what is known as an enduring power of attorney, which enables these powers to be used after the person has lost their mental capacity. Unfortunately, in South Africa, in 2004, the South African Law Commission was tasked with producing a report for government, which it duly did, but this has not been acted on, so we no longer or do not have an enduring power of attorney in this country. So, in essence, be very, very careful unless you have applied to court for the appointment of a curator bonus. Thank you for watching, and tune back for more videos in future. Goodbye.